I did try that jerky. It was pretty good. Okay, the Dowards are here. Oh, but Mr. Witty's on that one. Yeah. Okay. I see Deborah Winslow on Ford Motor. Nelson Mandela. That's a powerful name. Nelson Mandela is in the waiting room. Never imagined saying that.
Right.
Your Honor, could we be put in a breakout room possibly?
Yeah, absolutely. He's still connecting his audio.
Okay,
I think he tried to connect earlier and he had some issues.
okay.
I know, I mean, with the witty.
Nelson Mandela, can you hear me?
Yes.
Okay, do you have an attorney?
No.
Okay, I'm gonna put you in a private meeting room with the plaintiff's attorney so you all can discuss this case, okay?
All right.
That, did Mr. Smith withdraw the show cause? He's not here. Okay, I'll just hang on to that one. And then Mr. Reed is here. Jay Reed. Can you unmute?
My name's Joshua Gross. I believe it's just under my email account.
Okay, very good. Very good. Okay, we're waiting for Mr. Catterville. So we'll put you on mute until he's
Okay.
joined.
Yes, ma'am.
Why is it echoing? What kind of device are you on, sir?
An iPhone.
Okay. Okay. You don't have anything playing in the background, do you?
No, I do not.
Okay, I'll put you on mute. Okay. Mr. Grove, we got Mr. Mandela, Mr. Dowick. Who else do we have here?
Whitney Patterson and Ryan Nelson.
Why wouldn't he? I saw him walking down the street earlier. Where's he going? He's not gonna be here today for this hearing?
Whitney's not gonna be. Mr. Whitney, no, I think he's in doctor's appointment.
You're waiving your right to counsel then today?
Yes.
Okay. On the record in the matter of Todd Dowick versus Whitney Patterson, file number 22-03415 LT. Who's Whitney Patterson?
Yes.
That's you?
Mhm.
And so what's your name?
Ryan Nelson.
Okay, and Ryan Nelson. Today's the date and the time that was set for a motion to stop eviction. Looks like there was a default on March 1st, 2023. You all failed to appear in court. And default was entered. And it looks like you said that you paid the landlord for March's rent less court fees, which he said his son would pick up from the house in cash. He never came. He has always instructed me not to mail a late payment.
That's true.
Okay, first, why didn't you come to court?
Why didn't I come to court?
Yeah, you're supposed to come to court on March 1st.
I was at work, but this is not the first time that we have been in court. Usually what happens is we get and I had paid the past due amount, so I assumed that I would just have to pay the court fees at that time. I didn't know how much they were, which is why I only had a money order for the amount of the rent when Brad came to our house
When did you pay the past due amount?
on February the 28th.
And then I actually told his son personally to come back because all I had was the money order. He had to come back and get the cash. He left he left before the inspector left. So I'm thinking he's gonna come right back. He never came back. And then we get a letter in the mail talking about we got 2 days to leave. It's like they had this plan set up to evict us in the first place when we asked them to fix things.
Did they pay March rent?
They paid $1,000. The judgment was for $1,261.80. So they were $261.80 short.
What is the 261 entail? What was it for?
Court fees.
That's for court fees?
Court fees and the attorney fee.
Okay, so you accepted March rent?
I accepted a payment of $1,000
In
On-
February?
on March 9th.
March 9th.
March 9th, that payment. was
What did you
made.
pay on the 28th?
On the 28th, we paid $6,000, $6,500, and or whatever the original amount was of his complaint.
Okay,
I paid it in cashier's check.
and then March 9th, you
March is-
accepted the March rent
Right.
March 9th, $1,000 was paid
for the month of March.
for the month of March, judgment short $261.80.
Right. March 9th is when Brad was at our house
Right.
for the inspection.
What inspection?
There was a city inspection that they had scheduled. So I thought originally from February 28th, Ryan told me that they were gonna be back Thursday
And they never
to
came.
do the inspection, but they never came.
And
And
Your
so I
Honor,
texted Brad and he said it was actually the following Thursday. So I got a money order for March's rent. At this point, I still didn't have the fees. I didn't know the amount of the court fees. So when he came out on the 9th, Ryan gave him a money order and he was supposed to come back and we showed him some repairs that needed to be made before. And he said that he would come back then and he would get the rent.
The
The
cash, the
fees,
fees?
yes.
and Your Honor, can I
What day
say,
was that again?
That was on March 9th.
Okay, yes,
something? We've been staying in this house for like well over 10 and a half years.
okay.
Like, I never had dealing with Todd. Only time I see him is when it's the first of the month, you'll catch him riding down the street. Every time something fixed, I tell Brad, it's been multiple winters, the Florida flood. Now, I don't understand the basement. I don't understand, like, if we were in a house with a full basement, why we can't use the basement? Todd told me, oh, you can only use it as a storage room. Well, if I store anything down there, it's gonna get wet, so I don't understand why we wouldn't be able to use it as a basement.
You do recognize though, if you had, what you're telling me now, it sounds like a counter suit or a
Mhm.
defense. No, that's what you're telling me, that there were some underlying issues that you had. And you were supposed to appear at a hearing. I don't care how you thought it was supposed to work. I gave you a hearing date. Y'all blew me off.
My
I sat
ankle was
here-
broke.
You got a phone?
I ain't,
That's not my
you're
problem.
right, you're
That's
right.
not my problem. I was here. His attorney was here. All you had to do was log in. You could have logged in. You could have said, hey, I just paid this guy $6,000. We're giving him another $1,000 for March rent next week. But you didn't do that. And that would have avoided all of this. Ms. Jarrett?
We've been to court 19 different times. I
Not-
have 19.
Not on
different-
this,
No,
Oh.
no, but in the history,
of the 10 years.
I've got 19 judgments right here in front of me,
Yeah.
different times. The house is trashed and they've trashed it. It's in horrible shape. I drive by the house all the time. I see garbage out front. I'm asking repeatedly to clean up the yard. They won't do it. The house inside is in horrible shape. The inspector says the house is in horrible shape caused by the tenants.
The house,
So there was no agreement or arrangements with Brad to come back and pick up the rent. He was not asked. I
Well,
have.
how do you know? You weren't on the phone with them. You can't speak to what they talked
Well,
about.
he said there was text. I have the text between Brad and them. Brad's here to
You
testify.
all communicated via text?
no,
We
Ryan
don't-
spoke to
we-
Brad
I
on the
don't- I don't
phone
talk
and
to
he
him.
talked.
You spoke, who
He talked
spoke?
to-
I talked to
Okay, the
him
person who
personally.
spoke needs to talk to me. You spoke to him on the phone?
I talked to him face to face.
To face to face?
Yeah, in
No,
person.
ma'am, three people can't talk on my record.
Sorry.
She's making a record here. And you can't tell me what he did, because that's hearsay. He gonna tell me what he did.
I talked to him personally. The day, this is what, I don't understand. Out of all these years, it's like every.
I don't wanna hear about all the years, because that's not even before the court. The
Okay.
19
but-
judgments, not before the court.
I
What
talked to him
happened about
personally,
you paid him for March rent?
And he said,
On what date?
the night,
March 9th.
the night.
March 9th. And you received the rent on March 9th for March?
Yes.
I'm setting aside the eviction because you accepted it. And he had already got a default. You should not have taken their March rent. And he said that he had an agreement for him to come back and get the remaining balance. And that was before the rent date. The possession date said that they could pay that before the 13th.
We got the writ on March 17th.
It says here, on or before the 13th, they can pay that amount to stay in the property. You accepted it on the 9th, and he had an understanding that someone was coming back to get the balance in cash, is what he said.
Can Brad testify to that?
He can testify.
Brad, wanna-
Yeah, it was the $1,000 money order, and he said, here's $1,000 money order, and I took it. There was nothing, he didn't say anything else about anything about coming back. I mean, why would I come, if he didn't have it then, why would I come back later, like the same day? It doesn't make any sense.
So you just took the $1,000 money where you didn't know what it was for?
Well, I assumed it was for rent, but it was $1,000 money order. It said, hey, take this money order.
Right, and you have a judgment that said the rent to retain was $1,000 plus cost of $261? You just assumed it was just $1,000 being given to you?
Didn't know what he owed. All I know, people.
Perfect. I'm setting aside the default. Have you paid the $261?
No.
You have it today?
Yeah,
So you're gonna pay it today?
Yes.
yeah.
What about April?
April's month is
paid
actually in
for.
escrow
Right.
with the court.
They put their rent in escrow.
Okay.
I'll have it released to you. We don't do it out in here. You send the streets.
So that will be released. Could I pay the 261 to the court, or should I get a money order and give it to Todd?
You should give them the money.
Okay.
You should give it to them today.
Okay.
I'm releasing the $1,000 in escrow to Mr. Doward. Any additional matters for the record?
No,
Thank you.
thank you.
Ms. Winslow, you're all set in the meeting room with Mr.
Yeah,
Mandela? Okay,
Yeah.
Mr. Smith?
Good afternoon, Your Honor.
Good afternoon. Nobody appeared for Asia Moss. Did you want a bench warrant?
Yeah, this was actually a hearing after bench warrant. Did she post bond? I think your last bench warrant was 1,300. Was anything posted or did she self-report? I don't have the backstory.
Yeah, Yeah, it's noted on here. It looks like the magistrate gave her a $1,000 PR bond, even though my bond said 1,300. So
Yeah. Well, I can certainly submit another bench warrant. What would you like the bond conditions? What would you prefer the bond conditions say, Your Honor?
I'm gonna put no PR on here for the whoever arraigns because the person has failed to appear. And what is the amount due?
The balance as of today's date, Your Honor, $14,536.79.
Okay, you can set the bond at $500.
Okay, we'll prepare and submit. Thanks for your help.
Thank you.
You bet.
Okay, that one's done. We're on the record in the matter. Where's Mr. Cannaville? Do we know? We're on the record in the matter of Ford Motor Company versus Nelson Mandela and Nahumani Manueli. File number is 22-02030 GCE. Council appearance.
Good morning, good afternoon, Your Honor. Deborah Winslow, P 63179, on behalf of the plaintiff Ford Motor Credit Company.
It was the date and the time that was set for a motion for summary disposition. Mr. Mandela is present. Mr. Mandela, who is Nahumani Manueli?
That's my nephew.
It's who?
Your Honor, if I may, we did have a chance to discuss this matter at the pretrial and also again today. At the pretrial, Mr. Emanuele indicated he was going to be out of the country. We had discussed a resolution and we are in agreement to a resolution. And when we talked in the breakout room, Mr. Mandela indicated he would be able to communicate this information to Mr. Emanuele and have him sign off on a stipulation.
Okay, so you have come to a resolution?
Yeah, and if Your Honor would be willing to maybe put our motion over for 2 weeks just to ensure that we get the signed paperwork back,
I can absolutely do that.
that would be helpful. And that way our motion still, is there in case we need it. We can't get.
April 18th. April 18th at 2?
That's fine with me. And I did tell Mr. Mandela that we wouldn't need to appear if we got that signed paperwork in. And it would be a dismissal with a payment plan, Your Honor.
Okay, sounds good. Mr. Mandela, do you have any questions today?
No, I don't have no question.
Okay, any additional matters for the record today, council?
No, Your Honor, thank you.
Okay, Mr. Mandela, you're all set for today.
All right, thank you.
Thank you.
Thank you.
Uh,
Okay, let's see here. RPM, auto sales. Mr. Gradville did not appear today. But they did file a response, it looks like. On the record in the matter of RPM Auto Sales versus Joshua Lee Gross, file number 19-03623 GCE. Mr. Gross is present via Zoom, and representative for RPM Auto Sales have failed to appear. This matter was scheduled for 2 p.m. It's 2:20. Mr. Gross, you're requesting, whether you filed a motion for installment payment order, is that correct? You're muted.
I'm here.
Okay, very good.
Sorry about that.
No problem. Okay, you're requesting a installment payment, is that what you're requesting?
Well, the guy here, Craditchville, he garnished my state tax return. And, I mean, if that's my only option is just for an installment of $100 a month, or if we can just fully dismiss the case, I mean, I really don't know my options at this point. I'm sorry.
I got a motion and affidavit for installment payments is what I got. I don't see another motion in here. Not from- You filed a motion? Other
Yes,
than the one for installment payment order?
yes, ma'am.
What was the motion for? Because my record said that today was set for an objection to motion for installment payment order. That was what we got from you.
I believe his,
It says your average income is 1,200 to 1,400.
correct.
And that you owe on this judgment a balance of $3,600, correct?
I actually do not know the correct amount because they just took my state tax return as well.
Okay.
And
how
that
much
was
that for?
I believe it was roughly $1,016.
Got it. Okay, and so what are you looking for today, sir? What do you want from the court?
Well, I just put in a objective to his payment installments of, because I believe his were $200 per week. And
Oh, okay, got it. Okay, and you own a 2023 Escalade,
yes, ma'am.
and it costs $100,000 almost?
Yes, ma'am.
Oh, well, then you can afford to pay your debt.
Oh, well, yes, ma'am, I will.
So what's the problem?
I just wanted to lower the amount of the payment that he's trying to get, because the payment on my truck that I currently own, it's, a lot compared to what he wants for me to pay. It's $200 a week, $800 a
Right.
month.
Mhm. You knew you had this debt when you went out and bought $100,000 vehicle?
Well, I thought it was over the time limit because it's been like 12 years.
Yeah. Yep, well, you're gonna have to pay that debt. I'm not lowering the payment. You got $100,000 vehicle, so you must have plenty of money. And so there's no reason why you should still owe $3,600 on a debt this old. You should get it paid off so we can all move on.
Okay.
And I don't see where he's requesting for you to pay $200 a week. I see you're paying $100 a month. That's what we have here. I don't see where he requested 200. Let me see here.
He garnished one of my paychecks and it was, I believe, $200 in a week. And then that's when I had entered this objection here.
So he filed an answer to your motion for installment payments. He said he neither admits or denies the allegation contained therein, and leaves you to your proofs. He neither admits or denies the allegations that you can about your payments or the amount of your new vehicle. He says that he believes that monthly payments of $100 are not reasonably calculated to pay off the judgment balance, as $100 per month barely beats the interest accrued on the account. Additionally, defendant previously had an order for $100 monthly payment and failed to make them, forcing the plaintiff to set aside the arrangement. Plaintiff just recently served a writ of garnishment on the defendant's employer, and the plaintiff believes this is the only reason the defendant filed the motion. And so you must have already defaulted on your installment payment order. They garnished your wage or garnished your money, and that's why you're setting this aside. But you went ahead and bought $100,000 car, and you owe RPM from an old car that you, and so that's, to me, is grossly irresponsible. And so to come to me and ask for any relief, I'm not in the position to grant that for you. You've already defaulted on your installment payment. I'm going to deny your request at this time. Any additional questions today, sir?
Yes, I just have one potential question. It says on my court paper, if the plaintiff fails to appear, it may result in a dismissal of the case. Just curious of that.
It says may. That's what the may mean. May does not mean the same as will result.
Okay.
So he didn't appear, but there's already a judgment. So I can't dismiss the case because you already got a judgment.
Okay.
They appeared and got a judgment up to this point. Now they have responded to your motion in writing. And so because they filed a written response, that is in a sense an appearance, even though they're not here today to argue the same thing they put in writing. They objected in writing to what you filed in writing. And so you really don't have a leg to stand on that one, because you can't attack the judgment at this stage anyways. And that's what it means. If they fail to appear in the case, it may be dismissed. So if this was like a pre-trial and they didn't appear, then I would have granted a dismissal because they failed to progress the case. But they already have a judgment. This judgment has been lingering for a while. They've been trying to recover the money on the judgment so they could file a satisfaction of judgment and move on. And so that's what they're trying to do. They want to get the money that's owed to them under the judgment so that they could stop collecting on it and move on. And you should want to do the same thing, sir.
Okay, I just have one thing I would like to be on record, that I never received the vehicle because the vehicle was sitting at their shop getting fixed. And that's what all this had stemmed from when I was probably 19 or so. But that was all I have to say.
I recognize that. The problem in this is that you never appeared in the underlying case, and they got a default judgment against you. So you were served with the lawsuit back in 2019, and you never appeared. And so they got a default judgment against you with a judgment at the time of $3,921.09. That included damages, cost, and an attorney fee. And so over the time period, you did have it under the law. There's Mr. Crowderville right there. Good afternoon, Mr. Crowderville.
Good afternoon, Your Honor.
Okay, we were actually handling your matter. I didn't know that you would be appearing, but just to bring you up to speed, I did construe your written response as the response that you would argue today. And you can let me know if that's not the position you're taking at this time. But I advised Mr. Gross that I was denying his motion because he's defaulted on the payment plan before, and then even in his motion for installment, he's informing the court that he's got a $98,000 vehicle, so he has to be able to afford to pay this debt off.
Understood, Your Honor. And I apologize for being late. I had this improperly calendared, so that's my fault. But yes, I was hoping that the court would deny his motion.
Okay, and so he did bring up the fact that his understanding of the court rules is that if you had failed to appear, the case would be dismissed. I was explaining that to him. I said that really references the appearance in the actual case. There's already a judgment that he can't attack at this point.
Right.
And the judge, and so I was going over the default judgment because he then brought up that he never received the vehicle, which may have been a valid defense to you, Mr. Gross, at the time, but you never appeared timely to the case and argued any defense. They got a default judgment for you back in 2019. So you can't now bring up a defense now that they're trying to recover under the judgment that they got under default. You were supposed to, at the time, you could have filed a motion to set aside default. It looks like you did do that. And then you looks like you entered into an agreement after that.
Yes, that was for the $100 a month.
Correct. So you did get a default judgment. You did have it set aside, and then you appeared to court. And after setting aside the default, you admitted to responsibility because you got a civil judgment that you signed off on here, and that you would make these payments and that you would pay the balance of $3,921. There was an installment payment order which I signed back in June 2020, and you were supposed to make payments of $100 per month. And it looks like you defaulted on those. And so they requested to set aside the installment payment order so that they can garnish or issue a writ of garnishment. You filed an objection to that back in 2021. But they did still have a valid income tax garnishment. So that's why your income taxes were garnished, sir. They want, it's not a lot of money. And I don't own $100,000. That's a whole house. You drive a car that's $100,000. You couldn't possibly be trying to pay $3,000 off for the next 20 years of your life. You want to get that taken care of so you can move on.
I mean, I agree, but these guys are predatory lenders, and they caught me when I was at my down point in life. I was very young, and things happen. I'm sorry. I'll get it taken care of.
I recognize that you probably were dealt a shorthand in dealing with RPM, but that was something you agreed to. And so at this point, you want to get it behind you so you can move on.
Yes, ma'am.
Okay, any additional matters for the record?
Not for me.
Okay, you're all set. Thank you.
Thank you.
Who's on the iPhone? Sir?
Excuse me?
Not you. There's another gentleman. I think it says his name is Chuck. Is that Charles Trainer?
Yeah, it's Charles Trainer.
Okay, thank you, Mr. Trainer. Mr. Akanicki's here on both of those matters. And Mr. Trainer, you don't have an attorney, correct?
No, ma'am.
I have one more file. My computer. Oh, it's the same file. That's why. On the record in the matter. Oh, your computer went off. Oh, because it doesn't happen once a week, right?
Never happened before.
Yep, never. It's first time ever.
It was going good.
No, it was not. It was not doing good. This just happened on Friday. Today is Tuesday. You didn't use it on Saturday and
Well, they were
Sunday.
supposed to come yesterday, so
Yeah, I know, because you need, that computer is gonna
Exactly.
crash.
they said it was something with audio. I don't know.
They need to get you a newer computer. This one's trash. That's not. Okay, we got it back up and running. We're on the record in the matter of Leela Rahal, file number 23-0035 GC versus Shaniqua Culpepper and Charles Trainer. Council appearance.
Good afternoon, Your Honor. Robert Ockenick, the attorney for plaintiffs.
Thank you. And then I do see Charles Trainer via Zoom, and then I see Shaniqua Culpepper via Zoom separately. And Ms. Culpepper, your matter is set first for a motion to set aside default judgment.
Correct.
You was under the impression of talking to someone over the phone about what, ma'am? I'm trying to understand your request.
Oh, I was saying that I was under impression that I had to call the number off the paper. I didn't know that I had to write something in writing stating that I want to proceed to court.
Okay, so you didn't realize you had to have her appear or file a written answer. You received a summons, correct?
Correct. I thought I just had to kept calling the number that was on the paper. I didn't know that I had to write something.
Okay, it says on your summons, and it's kind of bolded, notice to the defendant, on number 2, you have 21 days after receiving this summons and a copy of the complaint, they bold this portion, to file a written answer with the court and serve a copy on the other party or take other lawful action with the court. You get 28 days if you were served by mail outside of the state. So you didn't read that portion, ma'am?
Yes, I read that portion, but I thought I had to just talk to somebody over the phone when I was served. He told me to just call the number off the paper.
Who's he?
The guy that served me.
Okay, I don't know who served you, but when you get a document from the court and it tells you what to do, you're supposed to do what that says, because the person who serves you is not your attorney, okay? So they don't have your best interest at hand, okay?
Okay.
Okay, do you have a defense or what you believe to is a defense to this case?
I feel like I can defend myself off of this.
No, what I'm saying is, and so you're requesting to set aside default because you didn't respond or appear in the court according to what it stated you were supposed to do in the court rules. And so in order for me to set aside a default, you have to first give me that you had good cause as to why you didn't respond or follow the court rules, and then you need to give me a meritorious defense. So meaning meritorious defense would be something similar to, I don't owe this debt, it wasn't me, or whatever your meritorious defense is. So that's what I'm asking you when I
Yes,
ask you, do you have?
I want to prove that I don't believe that I owe her anything.
Okay. Mr. Akanicki, did you want to respond?
Well, Your Honor, I understand that the process sometimes can be confusing for people that aren't represented, but as you stated, it's clearly written on the summons what you're supposed to do when you get served with it. I'm not sure that she's presented good cause or meritorious defense here to set aside the default, but I'll leave it at the court's discretion what to do.
As to the good cause, it does say very plainly that you need to file a written response, but you chose, ma'am, to listen to whatever you believe the person who was serving you stated. I do have the discretion to give leniency because you're not represented by counsel. But I'm going to tell you at this point, if you're going to proceed in this matter, you're going to have to read, especially what's bolded to you, and you're going to need to know what the court rules are, because I'm not going to let you just bulldoze and blow through a process and tie up the court process without following any other rules. Okay, ma'am?
Understand.
Okay, so I'm going to find that you have a good cause and a meritorious defense. I'll set aside your default.
Thank you.
No problem. And so Mr. Trainer is here on a pretrial. And so now you also have to do a pretrial. The purpose of the pretrial is for you to come to an agreement about the next steps in this case, or if you can come to an agreement in how you're going to resolve it, then you can do that as well. Let's see. I'm going to put you and Mr. Akanicki in a private meeting room. You all can create a joint final pretrial statement, and then what we'll do is we'll get you a scheduling order based on that, okay?
Okay, sounds good.
Okay, we're still on the record. Mr. Akanicki, were you all able to come to a resolution at all?
We weren't able to necessarily resolve the matter itself, but I think that if we could have just some discovery permitted, because I think they have some photos and I want to make sure I got those, and I'd give them any invoices that I have. So if we could have discovery completed and potentially go in front of some, do some type of mediator within 30 to 45 days. And if that doesn't work, a trial within 90 days. I think that's really all we need.
Pre-trial form. Let me get a joint pre-trial form and I can get that taken care of. Okay, are of the pleadings otherwise in order? I see a summons and at least one answer from Mr. Trainer. I'm inclined to believe, Ms. Culpepper, your defense would be similar to what Mr. Trainer's defense is, or
Yes.
or answer.
Yes.
Okay, I'm going to order that you file your written answer within 14 days, okay? You can get a copy of this answer form from the, by Googling online, really, a civil answer form, or you can get one from the court, okay?
Okay.
And you file your answer with the court and then get a copy to the plaintiff's attorney. You do that within 14 days.
I can do that today.
Very good.
Do I gotta fill one out too, or no?
Yours is already here, sir.
Okay.
Otherwise, the pleadings appear to be in order. How much time do you think you need for discovery, Mr. Akanicki?
Just 30 to 45 days, Your Honor, tops. I think all there is just, I'm just gonna send them some invoices. They're gonna send me some pictures.
Okay, let's see. I'm going to say today is the 4th. Cutoff will be May 9th. For discovery. Exhibits need to be exchanged 1 week prior to trial. There's no admission of facts, it appears. Any motions for summary judgment?
I don't.
Days. Okay. You say you don't anticipate any?
I don't. I think it's just a big question of fact as to who caused the damages. Okay. So I don't anticipate a summary judgment.
Very good. No expert witnesses?
No.
Okay, that's Ms. Culpepper and Mr. Trainer. Do you intend to call any expert witnesses? I don't perceive that you would need any.
No.
But it's up to you.
No.
Okay, I think she's got booted. Damages, Mr. Akanicki, that are being sought is $5,690.
That's correct.
It'll be a bench trial. I don't think I've seen a jury demand in here. No. Okay.
Bench trial is fine.
Okay, we'll set a bench trial after June 9th. And you think that you'd benefit from some mediation?
I do, Your Honor.
Okay, I'll order mediation in this case. Okay, I'll use this to get a copy of a scheduling order out to you all and get you set up for mediation, okay?
Thank you, Your Honor.
Thank you. Do you have any questions, Mr. Trainer?
No, ma'am.
Okay, you're all set. Thank you.
Yep, thanks.